Ladies and gentlemen, colleagues, thank you very much for coming back so promptly after lunch. And I'm relying on all of you to do your best efforts to stay awake during the siesta hour. But fortunately, we have two excellent speakers who are going to make presentations this afternoon and will certainly help you to stay awake with the content of what they're going to say. And we also hope that the people in the audience will contribute to the discussions from their own experiences. I've been invited by the truly wonderful organisers of this truly wonderful conference, not just to moderate this session, but also to make a few introductory observations. That was a foolish invitation because I can never say no when I'm given an opportunity to express my views. So let's go. What do we mean by civil society? And why has it come to assume such an important role in this field? So, of course, it's well understood that civil society doesn't include governments, who are the primary duty bearers and whose responsibility it is as parties to international treaties, such as the ECHR and the CRC, to ensure that children are provided with shelter, education, healthcare, information, and legal assistance as required by law, and that their right to maintain contact and relationships with their parents and other family members is duly respected. Governments may choose to enlist the assistance and support of other actors in meeting those primary duties, but they remain responsible for ensuring that those duties are carried out. They also remain responsible for ensuring that no one is unlawfully deprived of his liberty. Normally, deprivations of liberty are effected by state actors. But if detention has occurred, and it can be directly or indirectly attributed to the state, it doesn't matter whether those who are doing the detaining, knowingly or otherwise, are employed agents of the state or delegated bodies. And if the state delegates its responsibilities, for example, under the Reception Conditions Directive, to other agencies to carry out, it still has a duty to ensure that no child is being unlawfully deprived of his liberty. Our main task today, however, is to look at the role that civil society may play not in detaining children, but in providing alternatives to detention. So what do we mean by civil society? Does it include intergovernmental organisations such as UNHCR and IOM, or perhaps sui generis international organisations like the Red Cross or Red Crescent, national human rights institutions, or only non-governmental entities? We can talk about that. The role of civil society is to complement and supplement the execution of its duties by the state. It's not to be a substitute for the state. NGOs. The right to association is guaranteed in Article 11 of the European Convention on Human Rights, and we know that non-political organisations build social capital and trust and shared values which help society to hold together. And in many countries of Europe, decades of socialism meant that the flowering of social society was seen as suspect. And because we're here in Prague, we should probably recall the words of Václav Havel, who said, "The sphere of civic associations was threatened by the intrusive, holistic, state-dominated regimes of communist Eastern Europe." But in other countries, there'd been no tradition of such civil society to be threatened. And what we now think of as the classic role was taken by informal, often unorganized activities by individuals, often members of religious groups, and indeed such groups still make a valuable contribution to the plight of refugees and refugee children. NGOs come in all shapes and sizes. They can be religious or secular, they can be medical, legal, educational, they can focus on music or drama or the arts or the provision of shelter and clothing and legal advice and representation. And all across Europe, particularly in the Mediterranean region, they have made an invaluable contribution to the alleviation of the suffering of children seeking international protection. We think of the work done in locations as far apart as Calais and Lesbos. NGOs there have collaborated with governments and UNHCR to run or maintain reception centres, to provide health care vital to children to survive, or to give much needed legal and other support service in government-run centres. Some have carried out quite extraordinary work, not only in the face of logistical difficulties, the weather and the mud that comes after the rains often being one of them, and legal obstacles, but they've also met unconscionable bureaucratic intransigence in some circumstances. And for some, their role has had to be direct confrontation with governments and government policies. Some NGOs are rightly recognized as canonizable saints. We have some of those here today, and some of them have been rightly praised who are not here. Some have relatively large disposable resources or directly financed by states or UNHCR or the EU, and others, often doing disproportionately marvelous work, face a real struggle to find the minimal funds for their work to continue. NGOs also have an important role in monitoring the conduct of states in the field and ensuring that so-called reception centres are not in fact detention centres. They also need to monitor the conditions of detention or reception, not just for compliance with the prohibition on torture or inhuman or degrading treatment, but also to ensure that children have access to the education and health care to which they're entitled under the ECHR, the European Social Charter, the Convention on the Rights of the Child, and where applicable, EU law. And where other NGOs are delivering services, some NGOs need to be monitoring the other NGOs. Quis custodiet, custodes ipsos. NGOs also need to be carrying out the necessary and appropriate advocacy, often in collaboration with the Council of Europe or the UN Commissioners for Human Rights, or with national children's ombudsmen and national human rights institutions, to ensure that those states which still permit the immigration detention of children are persuaded to stop this practice. Also engaging, as we at the AIRE Centre do, in carefully chosen litigation before a court, such as the ECTHR, or taking complaints to the Committee on the Rights of the Child, may be the most effective avenues for bringing immigration detention of children to an end. But when all is said and done, it will be important that the relationship of trust between NGOs and governments is created or is restored where it has broken down. And of course, that trust is built, it was said this morning, with the children themselves. And we mustn't forget the children who are still sometimes detained in the context of forced return procedures. These children are particularly vulnerable because they have been remaining in a country for many months or even years before being expelled. And their returns require particular sensitivity and even an appearance of retention detention may exacerbate the feelings of abandonment and the sensation of being unwanted, which no child should ever have to suffer. If all the responsible states across the Council of Europe were both willing and able fully to deliver their primary duties to all these children, then NGOs could better carry out their supplemental and complementary activities, many of which they are valiantly trying to do now. Questions were asked this morning about funding. The Committee on the Rights of the Child has recently issued a General Comment 19, on public budgeting and states parties' obligations under Article 4 of the Convention. It's really instructive and should be required reading for all NGOs who need to lobby and advocate on behalf of children in hoping to find alternatives to detention. And we can't overlook the unfulfilled obligations of EU member states to take their allocated quotas from the hotspots or to utilize tools such as the 1996 Hague Convention, which were at their disposal. No one advocates detention, but children and young people must be kept secure and protected from predatory individuals and groups if they are held where people who do not have access to them. Sometimes detention itself may pose the risk. The challenge is to protect them without depriving them of their liberty. And individualized protection is the key. That's why it's so important for guardians to be appointed as soon as possible for children. But this means effective guardians, not just overworked public officials with too many children on their case lists even to know who they all are. Practical and effective, not theoretical and illusory, is the ECHR mantra. Children need individuals who know them to safeguard their interests, and they cannot be accorded the right to be heard under Article 12 of the Convention on the Rights of the Child if there's no one to listen to them. NGOs are able to fill many of these gaps, but they must do so in collaboration with the other existing players in the field. And our discussions today will look at those possibilities. These are really urgent problems. Children have only one childhood, and once that childhood is lost, it's lost forever. It cannot be regained, and children cannot be allowed to languish in detention during this crucial and irreplaceable period of their lives. So enough from me. I'm now going to introduce our key speakers for this afternoon. The first, and I'm going to try very hard to pronounce it properly, is Adriana van Dooijeweert, who is the board of the European Coordinating Committee of the European Network of National Human Rights Institutions. She's president of the Netherlands Institute of Human Rights. She's had 30 years of experience as a judge, including as a migration judge, and she was chair of the Dutch Advisory Committee on Migration Affairs. I could go on, but it would take all her time for speaking, so I hand the floor to her.
When I hear that, it sounds like I'm 90 or something. I'm going to be very brief because we've heard a lot already about the fundamental questions about detention, in migration, especially about children. I'm also going to be brief because I don't want you to fall asleep, because I know that Benoît has also a lot of very interesting examples to share with you. I'm not going to stick exactly to my text. This is for the interpreters, and I think this is the moment for a little round of applause, because they have been doing an excellent job until now. Thank you very much. Well, I would like to give some examples about how effective cooperation between NGOs, government, national human rights institutes can be. And of course, I am a board member of ENNHRI, but I'd like to stick to the Dutch experience because that's what I know most about. But I have some examples that are not Dutch. But I begin with the first Dutch example. You are a woman and you live in the Netherlands because you have a relationship with a man there. You live together with him. But you do fight a lot about everything. And one night the fight runs out of hand, terribly, and your partner starts beating you. And he beats so hard that the neighbors hear you scream and cry. They want to help you, so they call the police. The police officer who arrives sees your bruises and sees that you're very upset. And for your own safety, he takes you to the police station. And there he tries to convince you to report the crime. You say, no, I'm not going to report. And he says, yes, you should, because it can happen again. And if it's not happening to you, it's good that all these crimes are reported, because it gives people the feeling this is not accepted, so other men won't start beating them. And you say, no, I'm not going to report. And then the police officer finds out that the reason why you're not wanting or maybe able to report is that you cannot identify yourself. You don't have a permit to stay in the Netherlands. Then he's very effective. He calls the alien police because you're undocumented. And they come and they put you in detention. One moment you are treated like a victim, you are a victim, and a split second later you are treated as a perpetrator. Another example, it's in France, but it's told to me in the Netherlands by Professor Jacqueline Baba, and she's Harvard Professor of Health and Human Rights, and she specialized in the rights of children on the move. And she told me the story of Moussa. Moussa is a young boy and he lives in Mali. But there he lives in a situation of constant physical violence by his father. He leaves his home country after running around in the city, in his country, to find another place to live and to work. But then he leaves his country. He wants to find a new and better life in Western Europe. After some time, he arrives in France. He's 17 then. And he comes to the city of Compiègne. And this is, notably, the city where Jeanne d'Arc spent her last night in freedom hiding in the cathedral. Maybe he walks through a red light or he does something else which is not very, very bad, but the police see him and they start asking him who he is and whether he has any documentation. He has some papers with him and the police look at it and they say, we do not believe that you are a minor. You look like you might be 19 or 20. We don't believe you're 17. And before he knows what happens, all his papers are taken and he's put in a cell. And when he asks after many hours if it might be possible to have some food, the answer of the police officer is, ceci n'est pas un restaurant. If we hear these examples, as a chair of a National Human Rights Institute, I cannot help thinking about what's happening other than in terms of all the rights of these people which are being violated by this action. We're talking about the right to liberty, the right to security, the right to equal treatment, the right to health, and maybe even more. These stories are not fictional, not in Europe and not in the Netherlands. In the Netherlands, after many examples about people who were not ready to report crimes committed against them, NGOs sounded the alarm. And they stated that many undocumented migrants refused to report a crime against themselves because they were afraid of being deported. And this fear for the police made them even more vulnerable for extortion and for being ill-treated by, for instance, people that they were working for illegally than they already were. This not reporting makes me think of another example, which we heard about a few days ago. Last week, a part of a big report by Fundamental Rights Agency is published, and it will come out in, I think, 20 October, somewhere like that, it will be public. It's a big report about the situation of Muslims in Europe. And there were a lot of positives things in it about how people feel about the country where they're living in, about the government there. There's not so much mistrust as we sometimes think. But one of the things is, and that is very worrying, I think, that more than 34% of the Muslims living in Europe say that they once or more times have felt discriminated against. But that's worrying, but the more worrying thing is that an really increasing part of those people will not report the discrimination because they think it's no use, discrimination is becoming normal, so what the heck, we will not report. But back to detention and migration. After those warnings by the NGOs, we really got into contact with the police in the Netherlands. And they were saying that they seriously wanted to do something about this situation. And they started a dialogue with the NGOs who are in contact with undocumented migrants. And they wanted to identify together the causes of these problems, and they wanted to do something about it. I was speaking to one of you, yes, about doing things and not only talking. We've been doing a lot of talking here, and that's good because we need to think about what the problems really are. But like in Greece, acts are very, very necessary, and also in the Netherlands where the problems are not that severe, but we have problems. So they wanted to do something, and they set up, together with the NGOs, a pilot in Amsterdam to start with, and it was called Free In, Free Out, Reporting a Crime Safely. They worked together closely to make it a success. The NGOs used their network and their credibility among the undocumented migrants to educate them about their right to report a crime and to seek protection, and so they rebuilt their trust in the police. And if necessary, NGOs also supported migrants by coming with them to the police and helped them to report. And on the other hand, the police made a lot of effort to educate their employees about the right of undocumented migrants to report a crime and the prohibition to report an undocumented migrant to the alien police when he or she is a victim and seeks protection, because many police officers simply didn't know that they couldn't do that. It's been a real success in Amsterdam, and it's been enrolled in the whole of Netherlands. Well, Netherlands is very small, but we're doing it in all the police stations this way now. And of course, if you think of this situation and you put not a woman who has been beaten by her husband, or a boy of 18 or maybe 20 in place, and you put a young child, this is even more relevant that we have pilots like this. We have been talking about it many times. Trust for children is so much more important, especially when their parents are not there. They need someone to trust. And they come from countries where most of the times there's not a lot of trust in the police. So these pilots are very, very important. NGOs are so important in doing things like this. And why? Because I do think that for the government, but also for national human rights institutions, NGOs are our eyes and our ears. They know what's happening in the streets, in the reception centers, in the prisons, and we need them, and we need to have a dialogue with them. This constructive cooperation is very, very essential for the smooth running and the realization of human rights. By controlling states' activities and by mirroring its policies and its legislation in the daily practice of people, in what happens every day on, civil society acts as a necessary counterbalance to a state's power. Eyes and ears. And Xavier was speaking yesterday about this need to advocate. It is very, very important, but it's also difficult. And it's also challenging. Because working together is not always easy. First of all, for effective access to the government, civil society organizations are heavily dependent on the space that those governments give them. give them to exercise their right to assembly and to express their opinions without the fear of repercussion. And once they have this space to tell what they see and what they think that should happen, the next step is how to effectively cooperate with each other. And there are risks in this cooperation. On the one hand, we have a big diversity in the Netherlands, but I think everywhere in Europe, a big diversity of capacity and motivation between civil society organizations. And their effectiveness and their credibility is not always easy to measure for the governments. And on the other hand, governments have also to deal with the reality of the political climate. Let's look at Germany, let's look at the Netherlands, but also Denmark. And this climate in society and in the media sometimes exhumes an image of non-governmental organizations as leftish activists, and also sometimes they hear the reproach of, maybe I could use the word we heard this morning, aiding and abetting their only economy, protecting their own jobs. These are very bad reproaches which are absolutely not true, but we have to deal with them. And I mean, we're not with many people here, so I can tell you a little secret. Of course, it stays within the four walls. But when I was appointed by the government to be chair of the Dutch Migration Advisory Committee, this was the job before this one, I heard from several people, from trustworthy people, that in the cabinet they said, yes, well, but that's a very leftish activist woman and we can't put her in that function and what's going to happen? Well, you know, I don't think you have to be leftish or activist to care about human rights or to care about rights of migrants. I've never told anyone that I was speaking with a job about my political party. I don't have a political party. I do vote, of course, but I'm not going to tell you how leftish I vote. But this is what they say about, for instance, Defence for Children, but also the Refugee Council, Amnesty International. Lately, there were a lot of articles in the Dutch press about how the government reacts to migrants, and for instance, about the Turkey deal. And Amnesty was critical, the Refugee Council was critical, the National Human Rights Institute was critical, and the next day there was an article in the press naming us all together like this group of activists, leftish people that are only there to protect their own jobs and have big salaries and go to Prague for conferences. And that is something that we really have to fight for and against. Not because we like to go to conference, it's not that. Of course, it's good to meet each other, and of course, it's good to have good and bad examples to compare with each other. But we really have to be serious that we should not only be convincing the already convinced. We should go outside, and people should tell people outside what the problems are with migrants and what the problems are with very vulnerable migrants, children, but also, for instance, children with a disability. I mean, we were talking yesterday about a culmination of vulnerability. Well, let's say you're a child, you're a young girl, you're a migrant, you're unaccompanied, and you have a disability, which means that you need help to shower and to get your food. And this is not a bizarre example. We have many young people in our reception centers that have not only psychiatric or PTTS or something, but have psychological problems and physical problems, and who are extremely vulnerable. And you wouldn't want one of them in detention, but I think we are all clear on that. So cooperation is very important, going out is very important, and working together is important. And what can national human rights institutes do to help you combat these challenges? I think that one of our positive points is, of course we have many positive points, but for NGOs one of our positive points is that we have an institutional position. And we can help you to get access to the government, to data, but also to institutions, because we have the constitutional right to go into prisons, to institutions, but also to say to the government, we want this information. And Irene was absolutely right that what is known about detention in the Netherlands is available and is public, but of course not everything in prisons is available. And the Ombudsman and the National Human Rights Institute has the possibility to just tell the government, you have to inform me, and they have a legal obligation to do. So we could help you by getting access to information. And of course, we realize that as a National Human Rights Institute, to keep in a good dialogue with the government and to keep this independent institutional position, we also need to keep our distance. And that is why we do not answer on every question, could you please endorse this letter, or could you please send this to the Dutch government and sign that you agree with it. We are very, very careful with that, because we do not want to be an organization that takes every NGO on its back and says, we'll take you to the government. But we do work together a lot. For instance, for our strategic plan, every year we ask all our stakeholders, and that are about 150 organizations, what do you think is a very, very urgent problem that the Human Rights Institute should tackle the next 3 or 4 years? And we ask them by email, and once in the 2 years or so we meet them together and we talk with them. And well, of course, not only in the Netherlands, but also with ENNHRI, we did a consultation like that, so European-wide. Migration is absolutely the first and utmost urgent subject that everybody is telling us to tackle. So we're there to help. I will give you one other example. I think everybody in the Netherlands knows that in 2013 there was an incident in a Dutch detention center. There was an asylum seeker and he committed suicide in his cell. He had psychiatric problems, and also because of that, he feared his deportation to his country of origin so much that he couldn't handle his life anymore. After this suicide, there was a very emotional discussion in society about the humanity of detention of migrants. And that discussion pressured the government into making new legislation. Irene was already talking about it, on a more humane regime. And civil society had been asked for that for years. When it finally came, civil society organizations were disappointed. The regime, as suggested in this act, still contained a lot of risk of human rights violations. That was their opinion. And an actual framework of the ultimate remedy nature of alien detention and the application of alternative was not as strongly provided in the text as they had wished. That was the moment that our institute organized an expert meeting. And we invited all the relevant organizations, civil servants and the academia. And during this meeting, we could see that there was a fruitful and a respectful discussion. And that started there and then, and it led to more understanding on both sides. And then there was a round of feedback. What is there to change? What is possible? What is not possible? Irene already told it, we're sorry to say that we still don't have a new government, so this act is still not there, and we don't know what the next cabinet is going to do with it. And of course, we're going to use our influence again to keep the positive points in it and maybe even broadening them. And that is what we do together with the civil society. And we find this very, very important. Of course, in a broader field, we do this when it is about the situation of women. We are the official monitor of CRPD, the Convention of Rights of People with a Disability, which means that that is also a way for us to enter anywhere in homes for the elderly, in hospitals, to check whether this treaty has been followed on. So we're there to help you, and we try to do it by staying independent human rights institutes. We want to be also a constructive partner of the state authorities. We need that to have this good dialogue that I was speaking about. And of course, when you have an NPM, and when you are the NPM as a National Human Rights Institute, it's even easier. But in the Netherlands, we're still discussing what the NPM should be and who is going to take part. And that's also something that I hope is going to become clear with the next cabinet. If you want to know what happened to the lady who was put into detention, she was released. There was no view of deportation. And there were no alternatives for detention considered. And if you want to know what happened to the boy, well, he was released too, and he was put back to the streets without any information of what he should do now and what his rights were, and even without any information about whether they believed he was 17 or whether they still did not believe he was 17. So I think we've got a lot to do. And that brings me back to the discussion of this session. How can civil society cooperate constructively with governments and other stakeholders in achieving concrete results and advancing progress? Real progress, concrete and practical, in finding and implementing alternatives to detention and not alternative forms of detention. Thank you for your attention.
Thank you very much indeed, Adriana. We had a really good introduction to the role of national human rights institutions in a sort of triangular cooperation between the state, the national human rights institutions, and the NGOs. And now we're going to pass on to Benoît van Keirsbilck. I got that right, almost. Who is the director of the Belgian section of Defence of Children International. He was the former president of the International Executive Council of DCI. He's one of the founders and co-directors of an interdisciplinary centre on the rights of the child. Very important, that. And he's now going to give you his view about cooperation with all the stakeholders in this field. Benoît.
Thank you so much, Nuala, for the floor. And of course, I would start in telling that this is probably one good example of effective cooperation between state, an interstate organization, the Council of Europe, and the civil society. Having one panel, one session on this topic during this conference organized by a state is a good example. On the one hand, of the fact that the organizer recognized probably the importance of the civil society and what the civil society can bring to a discussion and a debate, and on the other hand, on the need to create places to exchange ideas and work together and try to build some solution. First of all, I should say that, as Nuala mentioned, there are so many different NGOs, and I will certainly not represent all of them. I will talk from the point of view of one, I would say, activist NGO, probably one of those leftist NGO as it was described just before. We are very often criticized in that way too, as if it's only some people that are able to talk on behalf of human rights and children's rights, and I do believe that it's not the case. I think that my intervention will try to answer to one of the questions I saw on the screen. It disappeared now, but the question is, what action needs to be done by NGO to stop detention of children? Because I wanted to not to be too theoretical, but starting from some examples on what we have been able to achieve in Belgium. I fully agree on the fact that what we did in Belgium is not possible in every country. We did it in a certain period of time. I'm not sure that we would be able to do it with the current government now. But let's start with this example. Around the years 2000, in the beginning of the years 2000, there were about 700 children detained in Belgium yearly. 700. Some of them very, very young, in families, sometimes alone, an accompanied minor with relatives, with friends. And you have heard about some of those cases because a few of them, only a few of them, went up to Strasbourg, and Strasbourg had to take a decision about the way they were treated in Belgium. And one of the first time Belgium was condemned by Strasbourg because of violating Article 3 of the European Convention on Human Rights was this particular case of this young Congolese girl, 5 years old, detained during 2 months, and then sent back in Congo without any proper support and supervision. One thing that the court didn't mention, that Belgium lost track of this girl during a few days after she was returned. Nobody knew where she was. Nobody knew, 5 years old. And so it took a few days before we found her back. She was taken in charge by a lady belonging to the secret services of Congo, and she just took care of this girl lost in the airport of Kinshasa. So to come back to this situation, there were about 700 children detained at that time in Belgium. But very few people knew about it because, of course, we don't know what's going on at the border in closed center. There is very few supervision. But fortunately, there were some organizations, NGOs, that were allowed to visit those centers. But the mission and the role of those NGOs was just to try to set up a dialogue with the refugees, with the migrants, and they were not allowed to give legal advice, to give any kind of support, just some moral support, I would say. But they decided to talk about what they were witnessing, and they started looking for organization to see what could be done about that. And together we decided to set up a system. Each time they were informed about the fact that a child was detained, they were just drafting a one-page report on the situation of the child. Age, name, alone, with parents, where he comes from, what was the situation. And with this document, we started to organize a network of lawyers challenging detention each time that there was a child in detention. Because before that, of course, there were very few lawyers with the right training and capacity to deal with those kind of cases. Most of the time, the time you are informed, you start an action, the person is already returned or disappeared, or I mean, it's too late to act. So we knew that it was very important to act very, very quickly. And so we, in 24 hours, usually there was a lawyer and there was already a request sent to a court to ask for the release of the child. So we started with that. We didn't know how far it would bring us, and it brought us quite far because we had to react about 2 times a day, which was becoming quite a lot for a small NGO. And we thought that we couldn't continue going on like that. Usually we won, I would say, most of the cases, if not in first instance, in appeal. But we had sometimes very strange decisions, and we had also a public prosecutor who decided to go in appeal each time the court decided to release the child. So we had also to fight against the ones who are supposed to ensure that the best interest of the child is implemented. So it was a kind of crazy world. But anyway, besides the fact that we had to fight against individual decision, we thought that we couldn't continue going on like that. We took some cases to Strasbourg, we took some cases, some legislation to the Constitutional Court, in Belgium, of course, press release, advocacy, lobby, and so on, this whole range of action and activities. But at one point, we thought that maybe to attract the attention of a broad public, we should try to organize other kind of action and activities. And we did one specific action was linked to the fact that one of those strange decisions coming from judges was saying that a child who is with the parents is not detained, is free to go at will. And so if we send a request for asking for his freedom of his release, the judge will say, no, he's not detained. Why should he ask for to be released? So forget about it. So we took this decision up to the highest court, la Cour de Cassation, the highest court in Belgium, and they confirmed the child is not detained. Okay. In that case, we ask all the parents of the children in detention to draft a letter and to sign a document saying that they give us the authorization to take care of the children during one day. We wanted to start with one day and to just organize some activities. So we rent a bus, we went to the center, it was a Sunday morning, very shiny day, and we thought it would be great to go to the sea because those children haven't seen the sea and some of them never in their life. And so we went there. We took with us some journalists, some members of the parliament, and some lawyers. And we wait at the gate until they gave us the children because we had the authorization of the parents and they were the only one to decide about the detention about what happened with the children. And the center refused to release the children. They called on a Sunday morning the minister and then the ministry himself, and they were confused what to do about that, but they decided not to release the children. So of course there was the press there. It made quite a scandal, and on the same day we went and we put a claim against the director of the center, the Ministry of Interior, and many people involved in that, because of arbitrary detention. If there is no legal order to detain a child and the child cannot go at will out when the parents say that they can go out, this is arbitrary detention. And of course, putting a claim against the minister is usually not well seen, so the cooperation between an NGO and the minister at that time was quite tense, as you can imagine. Second example, once again, if we want to try to find a global solution to a problem, we can continue over and over dealing with individual cases, but at one time we will be all exhausted, and probably the government is stronger than us and can continue on their side, and we won't be able to continue on our side. And so we decided to set up a court, a fake court, an opinion court, like we called it, which was organized exactly the same way a court is organized. We used the legal proceedings as per in the Belgian legislation. And we sent a request to the government saying that they have to come to this and to appear to the court on that day and to explain to the court why they are still detaining children. And during 2 days, we had a prosecutor asking why the Belgian policy is continuing detaining children. We had a lawyer of defense, but the government didn't appear, so there was a chair there, empty, because they didn't want to defend themselves. And who was the judge? The judge, there were two kinds of judges. On the one hand, you had international expert in children's rights who formed a jury of 7 persons dealing with international standards and so on, and issuing a long judgment with all the legal reference. And then you had a jury of 12 children, 12 Belgian children from 12 to 18, who sat there during 2 days listening to the witnesses, listening to children who were in detention and giving their testimony to this court. They also issue a judgment. As you can imagine, it was not a legal one without legal provision, but it was the strongest advocacy tool I've ever had. It was very, very strong, saying we heard so much about the way Belgium is treating children. We don't want to hear more about it. Children locked up, they are not able to go out and to play. They are not able to see their friends, to go to school, to go to the playground, and so on. So it was extremely concrete, but from the point of view of a child, what is important and what is lacking when it comes to detaining a child. And so this court, of course, issued a judgment. We had press release, we had press coverage, and so on. And then the children went themselves and brought the decision to the Prime Minister. We went there on the day of the meeting of the government. You know, they have a meeting every week. And during the meeting, we went there and we knocked at the door of the government. And then they stopped the meeting for 15 minutes because there were 12 children on the door asking to talk to the Minister of Justice and the Prime Minister. And they read the decision they took in front of the Prime Minister and the Minister of Justice. And this again was a huge way to show to the broad public how Belgium was treating children. So these are two concrete examples. Of course, it took us months to organize it, and it was a huge organization, but many organizations were involved in that. And, but as a way to inform the public on something that is done on behalf of them, it was, as you can imagine, very strong. So this to say that when you are an NGO, you want to influence the political agenda, you want to influence the way the state is treating children. From the first day, you will probably not set up a right collaboration and places even to try to discuss with the government. So you have to show who you are, what you want, to show that you have very clear vision on where you want to go, and not to compromise yourself, because at one point, of course, they were saying, okay, we can follow your views, but you should also understand that sometimes we have to detain, so please tell us when and how we should detain children. So they were asking us to tell them how to violate children's rights, but in the best possible way. So again, we have to keep our position as NGO. We have to know where we want to go. And of course, we can enter into a dialogue. We can try to find solutions. We can understand that it may be very difficult and complicated for a state to deal with this kind of problem. And sometimes it's also a problem with the public opinion, because we know how difficult it is to present to the public opinion that we are positive towards migrants, especially nowadays. So I would say that depending, of course, of the mission and the goals of the organization, what would be the main condition for an NGO to cooperate with the government? First of all, I would say that there is a need for a very strong civil society and with a capacity to act. It's easier to say than to do, of course. But if you are not strong, if you are not able to be taken seriously by the government, you will continue to shout in the desert, but without changing very much. I think that as NGO, we also have to have a clear vision and goal where we want to go, what are our principles that we want to defend, and this has to be very clear. We also have to work professionally. Too often there is a willingness from organization, but without the capacity to work professionally. And this is something that we have to organize in a way, and it's linked to be taken seriously. We also have to be able to assess our own capacity, achievement, and goals, because if you don't look at what you are doing and how you are doing, of course, you may miss the point. At one point, this will help to get a recognition from the government about the fact that they better talk with you and discuss with you instead of trying to deny your existence and undermine your work. There should also be a clarity between the role and responsibility between the government and NGO. Nuala already highlighted that, but it's very important to make sure that we don't do, as NGO, what the government should do, and we keep our position as NGO, not replacing the government in its role. We should ensure that there are places for a dialogue with the government, and this is, of course, linked with the... Hope nobody was hurt. This is linked with the first point. If you are taken seriously, you should be able to sit around the table with the government, but in formal settings, like National Commission on Human Rights, National Commission on Children's Rights. This is probably important too. For me, a strong NGO sector is a very crucial component of a democratic system. And I will give you one more example on this importance. In one of the NGOs I've been working in, dealing with individual cases and supporting children in their legal proceedings, we even receive money from the government to pay lawyers to act against the government. And I usually take this example showing that if we reach that level, this is to show that the government recognizes the role and the importance of the role of NGOs. And I will almost finish with that. We have to find, and it's a difficult task, we have to find the right balance between criticizing the action of the government and making concrete proposals for changes. And sometimes, as NGO, we have to participate to program of the government, but keeping our independence and our capacity to analyze and to criticize what the government is doing. Each one has its own role in the society, and we should try to respect that. But we can also ask the respect from the government, and because you took some example of a situation that shouldn't happen in a normal country. In Belgium recently we had our Secretary of State on Migration saying that the organization Doctors Without Borders was involved in trafficking of human beings because they were rescuing people in the Mediterranean Sea, and so this is a way of trafficking. When you hear these kind of things, you cannot say that this government is serious and should continue its task. So if someone has to be dismissed, I think that it should be this government who is saying these kind of things. So finding the right balance, collaboration, yes, definitely, we need to work together, but not at any price and not at the expense of the mission and the role of the NGO.
Thank you very much for that clear message. Work together, but not at any price. I think we can now turn to some of the questions that have come up. And one that is not actually up on the screen at the moment, but which I think was important, that was up earlier, said, how can you have a dialogue and be a partner of the state if you're a human rights organization which is monitoring violations of human rights by state institutions? It was very pertinent question, and I'd like each of you in turn, if you could, to answer it. Thank you.
Well, as a human rights institution, I don't think we are partners of the state. I wouldn't call it that. And that's exactly the difference. We have a dialogue. We know how to find each other. And we invite, when we organize expert meetings, we invite people from the government to come and talk with us and give us their views. But what you were talking about, Benoît, we never go so far as to give them advice on something we are against, and then they ask, can you tell us how to do it in a way that's legal? That's a threshold that we should leave. Keeping our distance that way and having a good dialogue is not incompatible with an independent human rights institute. So, partner, no, I wouldn't call our institute or ENNHRI, for instance, a partner of the European Committee. We're not partners, let alone partners in crime. So we speak together, we want to understand what the government does, why it does it that way, and we have the very fundamental task of monitoring human rights and of telling the government, also with proposed acts, that they ask us for advice on this, and we will tell them, either in a letter or in a meeting, if you do it this way, we think this is a violation of a human right. And that's it. We're not going to tell you how to do it better, because that's your job. So by being very careful and not being very partnerish, but in a good dialogue, respectful, I think we are not in the danger of being taken for the government, because we don't want that, because we also have the task of deciding on individual complaints about discrimination. So we need the authority of a judge, of a semi-judge, which means that people should be absolutely sure that we are not the government, that we're independent. So it's a good warning, but I do think that right now we are not in the risk of being partners, far from that.
Thank you. Benoît, did you want to add something to that?
Not much, because I fully agree with what Adriana just said. It's exactly what I was saying, finding the right balance. On the one hand, we should not only look at the situation from the balcony denouncing that this is not acceptable. We have to enter into discussion, sometimes tough and difficult discussion, because we know that the topics that we are talking about are not easy. We have to avoid to be instrumentalized by the government, the way I was showing, but we also have to make sure that we are not accomplice of violation of children's rights. What you were saying, partner in crime at no price.
Thank you very much. Because I'm a deeply committed Democrat, I'm going to go for the questions that have most people voting for them. So one is, as NGO lawyers, we often fight for procedural safeguards for detainees. Is that actually legitimizing detention? And I think in the context of our event here today, we mean the detention of children. Benoît, do you want to go first?
Yeah, of course, I like this question. I think that we have to use procedural safeguards because procedural safeguards are democratic safeguards, and we often forget about these safeguards when it comes to migrants and migrants' children. The principle should be there, and I will take some example. The fact that the child has the right to be heard by the judge when it comes to its something that is linked to its personal situation. At least in Belgium, but I think in many countries, the decisions are made just on the basis of a file without any proper hearing, or the child is considered to be too small to be heard by the judge. But a judge who really listen to the child and listen to the testimony of a child when he has been detained will probably be moved hearing this situation. So procedural safeguards are very important, but don't stick to that. use human rights principle and keep into account or in your mind that if you want one day to go further, not only at national, in front of national jurisdictions, but to use the international mechanism, you should use the arguments to be able to go up to Strasbourg or Luxembourg from the very beginning. And it's probably not as difficult as some lawyer may imagine, so I would encourage you to use all those international mechanisms.
And what about the, sorry, I'll come to you in a second, Adriana. What about the suggestion that this might be legitimizing detention? You don't think it does, just say so.
No, I don't think so.
Can I add something of that?
No, I don't think that it would legitimize as long as the aim is to make sure that the child is released at the end. It's using the available tools to obtain the release of the child, in my view.
Well, you were saying that you should see the question in the light of migrant detention, but I was thinking when I saw the question, if we turn it around, the difference really is if we were talking about criminal detention, and as a lawyer, you know that it's probably the best thing that your client stays behind bars. There's the difference. There you will fight for procedural warrants, and you're not saying, but I don't want criminal detention. The difference is that NGOs and more people think that there should not be migrant detention, and there should absolutely be no migrant children detention. But I do not think that as long as it's still there, and we all know it's not gone tomorrow, as long as it's still there, as a lawyer, you should also fight for procedural warrants. And I don't think you legitimize it with that. No.
Thank you very much. Shall we now move on to the very big question? Can NGOs really fully succeed in an area where states fail?
I don't know. I'm not an NGO, and I don't think they can alone. I think the whole big point of my presentation is that we have to do it together. And if states absolutely do not want to here, I mean, if you look at Poland, if you look at Hungary, at the position of the Polish ombudsman, of the position of NGOs there, we can see that if a country effectively denies being bound to treaties about human rights, then it's becoming very, very difficult, and NGOs can do what they want, and they should go on doing it, but they can't do it alone, and sometimes you won't succeed.
No, I agree, but it depends by what do you mean by succeed. It depends on what area or what we are talking about. If we are talking about succeeding in detaining children without affecting too much their right to development and health and so on, detaining children in best condition, I hope that an NGO will not be able to succeed in that. But if we are talking about trying to think about a system that will promote other ways of treating, other approaches, the so-called alternative to detention, then yes, but not alone, of course. And of course we need to be able to work together. This morning we heard in one of the presentations someone saying that an NGO should look for the financial means to set up alternatives to detention, and if the state doesn't pay, let's look at other donors, and if this donor doesn't pay anymore, you will find anyone else who will pay for it. But for me, at one point, the NGO is replacing the state in its obligation to provide right and appropriate accommodation and alternative. So I, as NGO, I would maybe try to find the first financial means to start something to show that it works, and then to ask the government to take over, and then use this as example to develop their own policy. But I will certainly not look for funding for them to do what they should do.
Judge Power Ford, I think you wanted to come in.
Yes, I just wanted to make two observations in relation to that question. And from my own experience as a former judge of the Strasbourg Court and judge rapporteur, I can say that I can give an example of how in a small context the work of NGOs actually does make a difference. Because it is the submissions of NGOs, for example, bodies like the Defence for Children, that can have a huge influence upon a judge rapporteur. And yet, when it comes to the recording of the submissions in a judgment, you know, because of the length of the judgment, they're given a very short space of time. But, you know, it's certainly speaking personally, in a number of cases, I can say that it was actually the submissions of third-party NGOs that were decisive in terms of helping me to make up my mind. So it's an area where I would certainly encourage NGOs to be aware of their power in that regard. And the second point I would just like to make is that follow-up stories matter. You just told us today the story of what happened to the little girl when she was in Belgium. A similar incident I can describe in the case of N versus the United Kingdom, this case where a woman who was HIV positive was returned to her home country, and it became the standard precedent that was cited by the courts in circumstances where, you know, there was no responsibility on contracting parties to provide care for people who were HIV positive. And it was through the work of an NGO that I became aware of the fact that N died 12 or 13 weeks after she had been returned. And yet we were using this case law repeatedly as a standard. And it was through an NGO then, because this information came to my attention, I was able to refer to it in a dissenting opinion. The subsequent case of SJ versus Belgium then goes to the Grand Chamber, and then ultimately the state settles. And then, you know, so I would just really like to encourage NGOs who are working in the field not to underestimate the impact and the power that they have, and to remember that follow-up stories matter. So when I read that question, my personal answer was yes, they can actually succeed where the submissions of a state can fail. Thank you.
Please do.
Yes, I completely agree, and I would like to add that also in some cases in the Netherlands, where we do an intervention, an amicus curiae in Strasbourg, we sometimes do this together with NGOs, or because the NGO asks us, if you do it, maybe if we do it together. So that's also one of the ways, because one of the questions, if we could mention more tools that could be used. Well, this is a tool which we can use in Strasbourg, and we can also help in Luxembourg to get a judge so far as to ask questions to the court. So there's a lot of tools.
Thank you very much. It's very gratifying to know that all those sleepless nights we've all spent doing third-party interventions were not for no use. Can we think of some other tools that might be useful, other than the ones we've already discussed, because our democratically voted question is asking us that?
I think that, yeah, we could also think of research. Many NGOs are doing research, are collecting information, are drafting reports. We have had many presentations of reports. We have many of them on the table outside. This also helps to just understand the situation, see the extent of it, because if you are only talking about one child in detention, you will not put the same efforts in that. But when it becomes a huge problem, then you need to know how big is the problem. So I think that there are many other ways, and concerning children in detention, I think that we also need much more knowledge in the consequences of detention on the health, the development, the future of the child. We know that it's very bad for them. We don't know how bad it is, and we underestimate, thank you, the worst that it does to a child. We have studies concerning children who have been living in families where they were mistreated, and we know that this is really bad for their development, their capacity to learn, their capacity to live in society, and so on. But we don't have that many studies, as far as I know, about children in detention. And I think that it's probably worse, even worse, than living in a family.
Thank you very much. That's bringing into the discussions another element, which is perhaps we should be looking more to enlist the assistance of academia. And where are we now? No, this one is directed to me, and as I've already talked more than enough, I don't think I will talk to people in the coffee break about that. We've done about actions by NGOs to stop detention. Let's have a look. In some countries, there is over-reliance by states on services provided by NGOs. How do we ensure that states are reminded of their primary responsibilities? Adriana.
That's an interesting one. I would like to say one of the means to do this is to stress with the government on a national action plan for human rights. To keep on stressing on strategic plans, implementing human rights, and by constantly keeping the government alert on what they're doing and what they're not doing. And that's a way of, well, making lines between responsibilities. We call it in the Netherlands the systematic responsibility, and you see it with decentralization. We have had an enormous decentralization in the Netherlands concerning healthcare, concerning well-being, and we had a lot of problems, and we still have a lot of problems. Because of this decentralization was in fact an operation of economizing. The cities and the villages have the feeling that the central government has decided, well, from 1st of January 2016, you are going to do this, and here is some money, but not too much. And we have also been speaking with the government about this systematic responsibility for human rights, for good care, for fighting poverty. And you can, of course, decentralize, but it never means that in the end the central government is not responsible. And one of the ways to do this is to have a national action plan for human rights, and is to really take the SDGs, the Sustainable Development Goals of the United Nations, seriously, combine these two with a national action plan. As Human Rights Institute, we keep governments to that, and NGOs should say what you also are saying, until here and no further. I'm not going to help you doing what you should do. And now I have to catch my plane.
Before Adriana leaves, we'd like to give her a round of applause for her contribution. I'm assured it's not because she doesn't want to stay, but because she has no control over the airlines. Did you want to add something to what she just said in that point?
Yes, and then I can...
And then perhaps you could answer the question about the new family detention center.
But first of all, concerning the fact that the NGO are service providing for the state, I mean, I don't mind per se, but we have to be clear that this is a kind of privatization of a public service. So we have other examples. So in this case, hopefully it's not a profit-making service. We hope that NGOs are not expecting to make profit on behalf of some services for migrants. So it depends, of course, of what kind of service the government is asking for. Maybe also you have to ask yourself, why would you do that, and what is the added value of this be done by an NGO instead of the government? So for some tasks I could understand, for other one it's not as clear. I think that very often the motivation of the government is that it's probably cheaper being done by an NGO. So are we there to make sure that we give a cheaper service to children? This is an open question.
And the Belgian Family Detention Center?
Yeah, I can, as you can imagine, I'm fully against this center. But this is a very tricky example, of course, because, first of all, the objective of the government is clearly to send a message to some part of the population saying, look, we are tough on migration, we set up centers and we will send them back. And this is the speech of one part of the government who really openly say human rights, it's good enough, and now we have to implement a policy which is tough against migrants. So that's, I mean, the reason why it is set up is openly that one. So that's very worrying because one uses the life and the situation of migrants for a political objective. And now we know that it pays using that argument. But now, of course, this touches all that has been discussed during those 2 days. Is it acceptable to have at one point detention as measure of last resort for the shortest period of time? But for me, the main question here is it possible to combine detention and best interest of the child? Because this is what the Belgian government is saying. Up until now, the legislation says, it's one of the countries where the legislation says there is no detention except in some very, very rare cases, but you know that the exceptions sometimes become the rule, and this is what we are afraid of. So this exception, but in this case, we have to ensure that the best interest of the child, the condition of detention, and so on, are in line with children's rights. I am intellectually incapable to imagine that you can combine those two principles, that you can detain on the one hand without affecting, without respecting children's rights and the best interest of the child. Probably I'm too limited intellectually, but this is my problem.
I think your intellect is not in question here. Can we perhaps, as there are 3 votes for it, I will very briefly mention, even though I said I wasn't going to talk anymore, a little bit about strategic litigation of NGOs in the field, and perhaps talk to you very, very briefly before we move on to Antigone's question, that we should talk about strategic litigation in the field. We have in Europe a coalition, a collaboration between ourselves at the AIRE Centre, ENNHRI, the European Consultation or Council on Refugees and Exiles, the International Commission of Jurists and the Dutch Council for Refugees, where we look at the cases that come up before the Strasbourg court, particularly in the area of asylum, and we assess them as to whether or not they're cases in which it's important for us to intervene, and we have a whole table that assesses the pros and the cons of intervening, and then we decide if we've got the capacity to do an intervention within the time framework, and then we decide which one of the organizations is going to lead, and then one of us does the first draft, and we recruit 500,000 people to do the supporting research, and then the other organizations critique it, and then we all sit up till 4 o'clock in the morning sending it off before the deadline. And that's one way of advancing, we hope, the sound development of the law. But of course, there are plenty of other ways in finding the right cases to take. And the mantra I always teach to my students is never take cases on bad facts. We can perhaps now move on to Metatos's question about for states to cooperate with civil society, it's firstly important to identify common grounds, areas of interest, which is not always simple. But you're thinking.
Yeah, I'm thinking. I wasn't sure to understand the question. But before I answer to that, I would like to just add one point to what you were saying about strategic litigation, and just to underline that the work that you are doing with this coalition is just incredible. And as it was mentioned by the representative of the Court on Human Rights, I do believe that it's crucial and it helps moving on. In the same line, of course, the European Court on Human Rights is one of the most important bodies we have to look at, but don't forget that there are other bodies in the frame of the Council of Europe and also in the frame of the United Nations. We can also talk about the Court of Justice in Luxembourg. When we talk about strategic litigation, we had several debates on what is strategic litigation, and we don't know, both of us. We also have to decide strategically to which body you should bring one case. Sometimes it will be to the European Court on Human Rights, but sometimes we will have to use other means. And so having a broad look at it is important. Now, to come to this question, common ground. I think it's crucial to have common ground of interest, at least to share some values and some principle, and to identify in the government the people with whom you can collaborate, because this is also maybe something that we didn't mention yet, is the fact that the government is not one body with only one position and that's it. In the case that I told you, we had extremely good collaboration with the Ministry of Social Services. We had good collaboration with the Ministry of Education concerning the fact that a child, when he is released, he needs to go to school very quickly. And so when you look at all the components of a government, you can also find allies in the government and try to see who will be on your side, who will also make points and try to make the solution easier to some extent. Not only the government, but also in the parliament. Sometimes it's civil servant who will help you to bring the solution. So don't see the government or the state as one entity. One should find a way in the government to find the right person to talk to.
Thank you very much. And on the litigation point, we should add that there are some admirable countries like Belgium and Ireland and Spain and Germany who have accepted the right of individual petition to the Committee on the Rights of the Child. And there are a number of cases involving asylum-seeking children currently pending before the committee. Our final question, and you have 1.5 minutes to answer it. What could we do against the fact that states are trying to restrict the work of NGOs? It depends on what countries. Adriana mentioned earlier the situation in some countries, Russia, probably Poland now, Hungary, Turkey, not to name all of them. I think that it's extremely difficult in those circumstances to make sure that you can continue working, because you, first of all, you may have to work to fight for your survival. There are so many ways for government to undermine the work of NGO in adding new rules, limiting the financial support, or obliging you to report or to register in different ways. So sometimes bureaucracy is even worse than
direct action. So I don't have a solution, but keep on fighting and keep on fighting together inside the Council of Europe. The conference of the international NGO is a very good tool also. Look at support outside of your country too. That could be my advice.
Thank you very much. I'm afraid we don't have time to get to some of the people on the floor who wanted to speak, but we did get through all the questions that were up on the screen. When I used to appear in the European Court of Human Rights in the days when President Wildhaber was the president, when counsel who were appearing for the applicant had reached 29.5 minutes of their 30 minutes allotted slot, President Wildhaber used to pull up his sleeve, look at his watch and go, and I don't want to get into trouble with the authorities here for keeping you away from your tea and coffee break. So thank you very much to Benoît, thank you to Adriana in absentia, and thank you to everyone who put such very interesting questions. Thank you very much to everyone.